Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3173. United States of America versus Michael Lawrence Rosebar, appellant. Ms. Bond for the appellant, Mr. Hubel for the appellate.
Good morning, Ms. Bhatti. Whenever you're ready.
Good morning, and may it please the court. Isra Bhatti on behalf of Michael Rosebar. I'd like to reserve 2 minutes for rebuttal. Mr. Rosebar appeals the district court's denial of his 3582 sentence reduction motion. The parties in this case agree that under step 1 of United States v. Dillon, Mr. Rosebar is eligible for a reduced sentence, and his revised guidelines range is 87 to 108 months, which represents a 13-month reduction on the high end of the guidelines range. The parties also agree that under Dillon Step 2, the district court must assess whether the authorized reduction is warranted in whole or in part. The district court here erred because it failed to consider whether the authorized reduction was warranted in part. That is, whether Mr. Rosebar deserved to have his sentence reduced to something between 108 and 119 months. Instead, the court here asked a much different question, an all or nothing question of whether Mr. Rosebar deserved a quote resentencing. And that is problematic.
A little bit about just where we are in terms of context of time. I believe that he is projected to complete his prison sentence on November 19, 2025. And mind you, a day extra in prison, of course, I'm sensitive to that. But what are you gaining here? You know, because you have to wait on the opinion. What are you actually gaining through this process for him?
Right. Yeah. Mr. Rosebar maintains an equitable interest in having his sentence reduced because that reduction in sentence bears on the likelihood of his any future motion to reduce his term of supervised release. And that's something that this court's addressed in Epps, where the court stated that where a supervised release term is still yet unserved, quote, because of the relationship between a prison sentence and supervised release, there seems to be a very substantial likelihood that a ruling that incarceration should have been shorter would influence the district court's readiness to reduce his term of supervised release. So obviously that is one factor that Mr. Rosebar still has an interest in. Of course, the projected release date is also subject potentially to change.
So not contesting conviction and then not contesting criminal history points.
That's correct.
Okay.
Would that consideration prevent this case from becoming moot on November 19 if we haven't ruled by then?
So there wouldn't be a mootness issue under Epps. That's
Based on
correct.
what you just said.
Based on yes, correct. Just to revisit why the term resentencing and the court's multiple references to resentencing is problematic. First, that reference and that understanding that the district court espoused is a blatant contradiction of the language in Dillon. Dillon stated, quote, 3582C2 does not authorize a sentencing or resentencing proceeding. Secondly, the district court's understanding of the inquiry being, does Mr. Rosebar deserve a resentencing is an all or nothing inquiry that sets the bar far too high for Mr. Rosebar. It further prevented the district court from assessing whether he was whether his mix of 3553A factors and his post-conviction conduct allowed him to deserve a reduction in part. And that is an inquiry that the court did not.
Generally, when we have these sentencing reduction schemes, if you will, from the guidelines, there seems to be a built-in assumption that the guidelines were reduced because they were too high under that particular conviction. And so does that mean that because the guideline sentences are low, that there's an assumption that defendants should automatically be sentenced within the new range because that's the more applicable range at that point in time? And that's the whole reason why the Sentencing Commission reduced the range.
Yes, I mean, I think that's a fair interpretation. I think Dillon obviously left discretion to the district court to decide whether or not the 3553A factors under step 2 warrant a reduction. Of course, we agree that
3553A factors, you're calling it kind of a resentencing, but why not, couch it as a reevaluation of the 3553A factors, and that you would look at, has anything changed, substantially from those factors? And in this case, the judge looked at victim impact. What is the loss? Like, certain things had not changed. Yes, he's got, Mr. Rosebar, favorable characteristics with respect to his post-incarceration relief, but the judge seemed to focus on the lack of remorse or some of the things that he did not believe had changed from the first sentencing.
that is correct. I think Your Honor is hitting one of our points on the head, which is that there are a number of factors that did not change, right? The nature and circumstances of the offense did not change. The two factors that did change, the guidelines range, as well as his mitigating conduct in prison, overwhelmingly favored a reduction in sentence. So we agree that the court struck the wrong balance, even, assuming it engaged in the right legal inquiry, it struck the wrong balance by looking at factors that did not change. And
but recidivism would be one of those factors too, right?
Correct. Recidivism is one of those factors, the likelihood of recidivism.
Looking at lack of remorse and impact on victims, the failure to really decrease the restitution as part of that recidivism piece too.
The court did look at the likelihood of recidivism, but we contend that the court did not engage in the right balancing as to that inquiry. It looked at the nature of the offense. And then, it referred to his, Mr. Rosebar's filing of various motions post-conviction, but gave a brief nod to some of his mitigating conduct, did not actually weigh that conduct. It appears that the court did not actually weigh that conduct in its inquiry. And that's why we pointed this court to Martin and McDonald, the two Fourth Circuit opinions, where the Fourth Circuit actually stated that the failure of the district court to give any weight to the, quote, redemptive measures that the defendant took was error. And here also, the court did not give any weight to those redemptive measures. And had it done so, had it actually engaged in it in the right inquiry, which is any part of this reduction, any part of this authorized reduction warranted? It certainly would have weighed those mitigating factors in the analysis and found that some reduction is certainly warranted. And again, in Martin, it's on point because there the defendant had very similar factors: a clean disciplinary record, minimal security prison, elderly age, various other pro-social factors, including strong family relationships. And the district court wholly denied any resentencing that he was warranted. That he was eligible for. And the Fourth Circuit said that the court must explain why, in light of the ample mitigation, the sentence remains wholly undisturbed. And here too, there was ample mitigation, but the court decided to ask the wrong legal inquiry, which is, is a resentencing warranted, rather than asking.
The district court, I'm just reading from its opinion, says the court turns now to the 3553A factors to determine whether in its discretion a reduction is warranted in whole or in part under the circumstances of this case.
That is correct.
That's the right legal standard.
We don't contest that the court stated the right legal standard. What we contest is its application.
Then you're just fussing over the discretionary balancing.
No, so as this court well knows, stating the right legal standard is one part of the inquiry. This court has repeatedly affirmed in Agibe, in Brown, Judge Edwards' opinion in Brown, that it's the application of that legal standard to the individual defendant that matters, and that the court needs a reasoned basis. We would review
the application for abuse of discretion. Right?
That's correct, but the court needed to provide a reasoned basis for this court to be able to exercise adequate appellate review. And here, the court, every time the court engaged in an individualized inquiry, it stated resentencing. Does Mr. Rosebar deserve a resentencing? That is not the same inquiry as asking whether any part of this authorized reduction.
Resentencing, I mean, it's just shorthand for in whole or in part, which is what he says in the topic sentence where he's diving into this.
I understand. And again, the reason why that's problematic is, first of all, it contradicts Dillon. Dillon expressly stated 3582 does not authorize a sentencing or a resentencing. Second of all, again, it's an all or nothing inquiry. There's nothing in that inquiry that asks, is any part of that.
If he had won to have the reduction, would you then consider that the resentencing was okay?
I'm sorry, can you repeat that?
If he had gotten the reduction, would you then consider the resentencing, as you allege, was
So
okay?
it's a reduction in sentence, and if he had gotten his actual reduction, we would obviously, I mean, that would be okay, but that's not a resentencing. That is a reduction in sentence, right?
But
And if he is,
that's why I'm calling it a reevaluation of the factors. That you're saying resentencing, but I think that's semantics.
right, I mean, if the court, the question is, what does the district court, what did the district court here do? Right?
Good.
And in looking at its individualized analysis, every time the court looked at the various factors, victim impact, the nature and circumstances of the offense, the post-conviction conduct, the likelihood of recidivism, every time the court stated, does this weigh in favor of resentencing? And at the end of its opinion, it did not say or even indicate that it engaged in an inquiry as to whether the reduction was authorized in part. And I know that the term resentencing, it might be confusing, but the point is, does it seem from this opinion, does it appear that the district court actually engaged in an inquiry of whether any part of the reduction was authorized, any part, 2 months, 4 months, 6 months, and it does not appear that the court engaged in that inquiry. And it certainly, for purposes of appellate review, there's not a reasoned basis under, Aguirre and Brown, again, that would allow this court to be able to review that decision and say, yes, the court engaged in that partial inquiry.
Any other questions, Judge Giles?
No.
Judge Edwards? Okay, we'll give you some rebuttal time.
Thank you.
Morning.
Good morning. May it please the court, Mark Hobel for the United States. The district court did not abuse its discretion in denying the 3582C2 motion. It committed no legal procedural error, and its denial of a sentence reduction pursuant to the 3553A factors was substantively reasonable.
Do you think this will moot if we manage not to get an opinion out by November 19? Or do you agree with your colleague?
To be honest, Your Honor, that was my assumption coming in, is that it would moot. I hadn't looked at EPS or really thought about that issue, but it had been my assumption that it would moot. With respect to, I guess my plan was simply just to respond to a few of the points raised by Mr. Rosebar's counsel here. First, as to the legal question, the procedural issues, Rosebar argues that the district court treated this as a plenary resentencing proceeding, didn't follow Dillon, treated this as an all or nothing approach, and that's belied completely by the district court's thorough order. It stated, as Judge Katsas pointed out at page 85 of the appendix, it specifically applied the correct legal standard and asked whether a sentence reduction is warranted in whole or in part under the circumstances of this case. It also, at page 87 of the appendix and page 7 of its order, specifically noted that factors that the nature, circumstances, and scope of the defendant's fraudulent behavior weigh against any resentencing. So it clearly recognized that it had the authority to grant a partial reduction in sentence, but found under its discretionary balancing of the relevant factors that no reduction was warranted.
Would you agree that there needed to be a reevaluation of the factors? Like you couldn't just simply say in relying on what I previously sentenced, I find that there's no need for a reduction if that's all that happened.
I agree with that. I agree with that completely. I note that this was a different judge. This was Judge Kohler-Catelli, I believe, and Judge Hogan was the original sentencing judge. So there was a reevaluation in that respect. And there was a specific reevaluation conducted in this order.
And are you familiar with Judge Roger Gregory's opinion in the Fourth Circuit stating that just to merely recite your prior sentencing factors, essentially, that's not the basis for denying a sentence reduction?
Right. And I believe that was a concurrence in the context of a compassionate release, which is a slightly different posture than a defendant would have to show extraordinary and compelling reasons. But the district court here did correctly note that it had to evaluate this pursuant to the 3553A factors, and it discretionarily may consider post-conviction information. And in fact, it did so here and balanced it very carefully. I'd suggest that Mr. Rosebar's counsel suggests that the district court struck the wrong balance, and that's not a basis for this court to reverse as an abuse of discretion. The balancing of the factors is entrusted to the discretion of the district court. And so long as it was substantively reasonable, and it was here, this court should affirm. There was a question, I believe, Judge Childs, as to whether this court should, whether in a 3582C2 motion, there should be an assumption that the new guidelines range is appropriate. And this court has rejected that. And I'd point the court to Galaviz and United States v. Jones, which was cited in Galaviz, which specifically said that there's no downshift assumption that as long as the trial court appropriately balances the 3553A factors, the ordinary substantive reasonableness review applies. Here, the fact that another judge could have weighed the factors differently doesn't mean that Judge Kohler-Catelli abused her discretion in weighing them the way she did. And indeed, given the serial frauds perpetrated by Rosebar that literally destroyed people's homes, I think it was a fully appropriate balancing of the factors here and weighing his clearly recognized his admirable, that's what Judge Kohler-Catelli said, admirable efforts in prison, his work, disciplinary, and education in prison, against his utter lack of remorse, and drew the appropriate inference that lack of remorse and the nature of his crimes means there's a significant likelihood he will reoffend when he is released. And then just very quickly to note, before I sit down, Rosebar has pointed to a couple of decisions from the Fourth Circuit, Martin and I believe McDonald. And this case is very different from Martin and McDonald. In Martin and McDonald, the district courts did not even mention the positive rehabilitative information in their very, very brief orders denying 3582C2 motions. Here, the district court clearly recognized, again, deemed it admirable and simply found that it was outweighed by other factors. So I guess unless there are no further questions, we would ask that this court affirm.
I want to be clear in what you were a little bit quick in your response on potential mootness. Mm-hmm. I was surprised that you were saying, I don't know, I just assumed it would be in our favor. I think that's not correct under the law. I don't think it would be moot under EPS. And that line of cases, if we were to determine that they had a viable petition or a viable appeal because of what the Supreme Court has said, there are other factors to be considered, even if your sentence has been completed.
Right. That may well be true. I had not thought to look at EPS or thought about the supervised release question.
You're saying that too comfortably, but I'll leave that for another day. I mean, it's a potential issue. We'd like to hear from the parties on potential issues. I want to make sure you're not suggesting to the court that the government's position is yes, definitively would be moot. That's because I don't think that's right under the law. It depends. It would certainly depend on what we decided to do. But if we were inclined to go with their position, it was after the November 19th date, that case is not moot.
Right. And in part, this is, there is still more than a month and a half remaining. And of course, any single day in prison, would not moot the case. So this may not be.
We're talking about the potential mootness.
Right.
That Epps in those line of cases we're talking about where the sentence is done.
Yeah.
And the claim is made, well, there's nothing to be said. And the court said that's not accurate.
Right. If the court would like the government to look into this further and submit, so I'm happy to do that. I just don't know.
Make sure you're not boldly asserting something that surprised me, but you are mostly saying I haven't thought about it. Is that right?
Oh, that's right. It was the opposite of bold, Your Honor. A very caveated, I suppose.
You meekly suggest.
Well, I don't want to go that far, but that's up to the court.
You can go
Thank
that
you.
far.
Thank you. All right. Thank you.
Thank you, Counsel.
Yeah.
We'll give you 2 minutes.
Sure. Thank you. Just a couple of quick points. The government points to the word any. That word was used once in the district court's analysis. Again, there's no indication in its analysis. Appendixes pages 86 to 89. At no point did the court consider whether a partial reduction was warranted. And just, I thought an analogy might be helpful here to understand why the court did not engage in the partial inquiry, as the government asserts. Let's say that at my house, I have a policy where my kids are eligible for a slice of cake if they've eaten dinner, and I must decide whether they get that slice of cake in whole or in part. And let's say that my child asks me after dinner, he's eaten dinner, I would like half a slice of cake because I know I've been fighting with my sister. I know you're upset with me. I would just like half a slice of cake. If I just say no, I have not engaged in the right inquiry. I need to determine whether he is entitled to any part. Is he entitled to a quarter of the slice of cake, a third of the slice of cake?
No, but
I might deny him.
You ask yourself, is he entitled to cake in whole or in part?
Right. If I've engaged in that inquiry,
question.
if I've done that inquiry, if I have in fact engaged in that inquiry and said, is he entitled in any part to the slice of cake, then you are correct. But if I simply say, no, you don't get half, and that's all I've said, and all I've engaged in is, does he get half? Then I have not. And that's what the district court did
on the
here.
household. A lot of kids would know exactly what you.
And I think a lot of members of our audience might understand that too. But that is
Right,
essentially
in the
what
rules of this house. You violate my rules, you get no part of the cake.
right, exactly.
But even
yes.
under your hypo, you make an assumption that the judge has to ask or put on the record the specific question when everyone knows why you're there at that hearing. And then if the judge goes back into discussing the 3553A factors and basically answers the question without stating the question while you all know that you're there, is that not sufficient?
Well, all we know is that what is written in the opinion, right? There was no transcript from this hearing, and the judge stated the correct legal standard. But in its application, there was no point at which the court looked at, is any part of this authorized reduction warranted, right? And if the court had said, I've balanced these factors, I've considered the mitigating evidence, and no part of this authorized sentence is warranted, we would be in a different position. But this court has stated numerous times in Aguirre and Brown again, that simply stating the correct legal standard is not sufficient. It's the application of that legal standard that needs to be reasoned, it needs to be described, and it needs to provide an adequate basis, a demonstrated reasoned decision-making, and an adequate basis for appellate review. That's been well established in this court. And here, there's nothing in this opinion that provides that demonstrated reasoned decision-making that allows this court to exercise adequate.
You really
appellate
can't
review.
read the district court to be saying recidivism outweighs the other considerations, given the way that opinion was written. Isn't that what's being said? It
And
outweighs.
And lack of remorse.
And lack of remorse. Those,
To be
it
honest.
seems like it leaps right out and says, I know all of what I'm supposed to consider, but these two outweigh the others.
You know, I would be with you, Your Honor, if she had said no part of this authorized sentence is warranted. But to me, looking at, if we're talking about just risk of recidivism, and we know what the policies of the Sentencing Commission is, we know that they've crunched the numbers, and that's why they even enacted Amendment 821, in addition to all his pro-social factors and his mitigating evidence, that to me suggests that at least some part of this one changed factor warrants a partial reduction. And we simply disagree that the court has engaged in that inquiry.
Any other questions?
Thank you.
Thank you, counsel. The case is submitted.
Thought you were leaving. I thought you were leaving.
Case number 24-5155. Friends of Animals Appellants versus United States Bureau of Land Management, an agency of the United States and state of Utah. Ms. Beth for the appellant, Mr. Peterson for I believe U.S. Bureau of Land Management, Mr. Geary for I believe state of Utah.
Ms. Best.
Thank you, Your Honor. May it please the court, I'm Jennifer Best on behalf of Friends of Animals, and I'd like to reserve 1 minute for rebuttal. Today, I'd like to emphasize the importance of this case because the open-ended decisions to round up and remove wild horses eliminate valuable public input and disregard important safeguards that Congress put in place to protect wild horses.
Can I start you where we have to know you can satisfy as jurisdiction? The case law is pretty strong. In a remand order like this, there is no jurisdiction that the court has, and that has been stated in very strong terms by a number of our colleagues over the years. I realize that it can go both ways, but I don't understand, using the analysis that's appropriate, what you would effectively be denied if we say we don't have jurisdiction now. Because when you look at what the district court is ordering, the district court is simply saying there are things you have to go back and do, make sure you do them appropriately, but that's it. And in the cases that I've looked at, we've done it more than a couple of times. There's no jurisdiction here.
Well, Your Honor, under the 4 sort of factors of jurisdiction, it does indicate that we do have jurisdiction. I think the issue is when the court issued a final decision, it gave jurisdiction back to the agency. It said this is final, it is not going to make another decision, and essentially said that BLM can continue to round up and remove horses as many times as it likes until it achieves an appropriate management level.
No, it actually says a number of things that can easily be challenged by you folks later on if the guidance or the questions raised by the district court have not been effectively attended to. Conduct the required gathers promptly as reasonably possible. That's a potential fight later on. You can't take an entire decade to act, but there's nothing indicating you must act within 8 years, 9 years. You must use then available inventory when you do gather again or propose to gather again. These are all things where the district court is sending things back to be attended to. And that's exactly the kind of cases I understand the case law. We said we don't have jurisdiction to take this.
Well, Your Honor, Friends of Animals' concern is that each time BLM makes a decision to round up and remove horses, it should comply with certain statutory requirements. The district court said it was okay that it doesn't comply with those statutory requirements every single time it rounds up and removes horses. It remanded back to BLM, who has not made, any indication that it's going to change its decisions. These decisions are still in effect and will remain for years, and it can conduct a separate roundup to remove horses under those decisions.
Do you think on remand the BLM could lawfully just leave these orders in place with an extra explanation? Just, they say a bunch of more words about how hard it is to manage these things. It's oh so terribly complicated and we really need a decade, so we're not changing anything. Do you think that would be lawful under the district court's opinion?
Well, Your Honor, that is what BLM's doing, and our concern
They
is,
haven't decided yet. It's pending on remand, right?
well, on remand, BLM's position is that it can keep rounding up horses, and we've seen them in other cases. They are continually rounding up horses, and I think our concern.
Okay, but the district court's opinion, it's sort of a Goldilocks opinion, right? He says there are extreme positions from the parties, and yours is you only get one gather or roundup, and theirs is they can take 10 years. And he's saying neither of those extremes is right. There are a whole bunch of line drawing problems about how long is too long and how much information you need. And he sends it back to the agency to work all that out.
Well,
That seems like, if one of the major inquiries on finality is the nub of the controversy still open on remand, it seems like a textbook case where lots of core issues are still open.
Your Honor, I think the core issue for Friends of Animals is that on their face, these decisions violate the law. That core issue was resolved by the district court's opinion. He said on their face, it does not violate the law. He claims that Friends of Animals.
No, I don't think he said that. He said does not violate the law merely because more than one gather is allowed.
Correct, Your Honor. And that is a core issue that Friends of Animals disputes. And we don't think our position is extreme because this is the position that the Bureau of Land Management took for nearly 50 years and is only now changing it.
All right, fair enough. But let me give you one other consideration. So broad range of discretion still open on remand. And the other one is whether or not it's extreme, your position on one end of that spectrum will be fully open for you to pursue on appeal later.
Well, no, Your Honor, because respectfully, the district court judge said, he's drawing the line in the middle and that on their face, these decisions don't violate the law. This is a core dispute that Friends of Animals has. We believe these decisions on their face do violate the law. And it is significant.
Right, I think you're overreading the opinion, but even if I'm wrong about that, it goes back on remand and the agency shaves 10 years down to 8 or 5 or 2 or whatever, right? You go up to the district court and he says that's okay. And then you take the appeal and argue everything you've argued to us. Bright line rule, one gather only, immediate means immediate. And all of those issues are teed up for us later.
Well, Your Honor, one thing I'd like to point out is that the district court said this was a final appealable order. BLM doesn't dispute that.
You have the formality of the order in your favor, but he doesn't have final say on what satisfies 1291.
And the practical implication here is that BLM doesn't issue a new decision in remand. It lets the course of 10 years run, and Friends of Animals is stuck never being able to appeal these decisions. And it's every indication.
They let it run. What decision is that to? I don't know what you're talking about.
So there's.
They let it run. You're talking about the 10 years.
Yes.
Yeah.
So then the decisions. Friends of Animals can't challenge the decisions any longer.
What?
The fact that BLM can continually round up and remove horses in these 4
They're
HMAs.
going to have to do a new plan at that point if the 10 years run. And that's going to be subject to review. That's what's so odd about this case. I mean, the 10 years is almost done.
Well, I think
I'm not sure. What is it that you want? That anytime they think about a gather and reduction, that has to be subject to full process? Is that what you're saying?
Anytime they actually remove horses. So right now, what could happen is next year, they're going to say, we're going to remove 1,000 horses with no notice to Friends of Animals, no consultation. We try to go to the district court and they say, this decision has already been decided and we have no relief.
That would be subject to, you could go back to the district court.
Your Honor, we can't because they're not going to issue a new decision. They're relying on the decisions.
They're going to make a statement. It's not going to be in hidden. Someone is going to know they've made a decision to round up and reduce.
Well, according to BLM, they could make that decision.
Listen about what BLM says. I'm saying what the district court was suggesting. There's some guidelines. You can't take a full decade. Do it promptly, as reasonably possible. Don't ignore material new information. Then available inventory and other information. So using those considerations, you could come back in and say, no, they are now suggesting they're going to do a gather and reduction, and and they have not followed what the district court suggested they needed to consider. So we're challenging it now, and they cannot pursue this gather and reduction because they're not doing what the district court said they had to do. They can't just rely on the 10 years. They have to take the information that's available to them at the moment that they're proposing to do something. District court's very clear in that. And you clearly could come back in.
Well, Your Honor, respectfully, we don't agree with the standards that the district court set. That's what we're here appealing. And
what standard is that?
So according to the Wild Horse and Burro Act, BLM has to make a determination based on an existing population that removal of excess horses is necessary, and it must consult with independent parties when doing so. So we think that standard laid out in the law is what should apply, not what the district court said. And so because these decisions on their face exceed that, they're not limited to an existing overpopulation, and they're not consulting with individual independent parties when they're making them. That is our concern. And that is what we're asking this Court of Appeals to decide. And as a practical matter, which is a consideration in jurisdiction, when BLM says we're going to remove 1,000 horses next week, Friends of Animals doesn't have time to challenge that decision. And arguably, we wouldn't have jurisdiction because our concerns are that the standards set out in the act should apply and not the standards set out by the district court.
If you were right, wouldn't any district court order in an APA case remanding without vacature be immediately appealable?
Well, Your Honor, if the district...
The party that's, established the need for a remand but not getting vacature can say, well, gosh, the order's still in effect and bad things might happen to me in the interim until the agency cleans up the remand.
It kind of depends on sort of what the remand is. And if it's clear that the judge is saying you have to, meet these certain requirements and the plaintiff doesn't dispute those specific requirements, then it's possible that the remand order is not immediately appealable. But here where Friends of Animals does dispute the standards set forth for remand, then it is immediately appealable, especially when we would not have an opportunity to litigate those on remand because the district court set different standards. So we can't go back to the district court and say, we disagree with this because of our concerns with the Wild Horse and Burro Act, because the district court would say, I already said that was okay, that they have some discretion in the middle, where Friends of Animals is appealing that, in fact, the act doesn't give them that discretion.
Tell me again, what is the legal standard that you feel must be overturned?
We believe that on their face, if the decisions go beyond an existing overpopulation and what was necessary at the time of the decision, then those on their face violate the Wild Free Roaming Horses and Burros Act.
Are you talking the decision with respect to the original plan? Because we're not talking about the appropriate management levels. Those are fixed, right? So you have lots of variables after the appropriate management level is fixed. Then you have plans. And are you suggesting process is required when the initial plan is established pursuant to the management level, and they can reduce. You got notice, you participated in that process in determining what should be in the plan, and then they act. Now, you know as well as I do, you can't always achieve it fully, just given the wilderness and the problems out there. You don't always meet the mark, right? So there are going to be follow-ups, and indeed, that's clear from the record. So you may want to reduce by 100 horses, but because of a lot of variables, everyone realized it was not possible to get 100 horses. So we're going to continue that a little bit later. Now, are you saying when they continue, the district court, what are you saying? You surely contemplate that possibility, right?
Yes, Your Honor.
Are you saying there has to be a new process to go through the whole thing again? We couldn't get the original 100.
Your Honor, so what BLM did for nearly 50 years
Tell me
is
what
each
you're
time.
objecting.
So
Tell me
my,
what you're
yes,
objecting. I don't care what they did before. What
Okay.
we have now, I'm sorry, I don't
Yes.
mean to be impatient, but I really am impatient on this one because I'm not getting it. What is it you're concerned about? You have an original, the AML, you have the plan, and then they act pursuant to the plan. And process was clearly given. You participated and everyone agreed we're going to try and reduce and eliminate 100 horses. It doesn't work out for perfectly reasonable reasons. It doesn't happen. So that plan to get rid of those 100 is going to be delayed. It's going to happen a little bit later. And they come back and say, okay, we're going to do it now. We're going to get the additional 75. You saying there has to be a new process now?
well, Your Honor, these decisions don't say we're going to remove 100 horses. They're going to say we remove horses to a set target. So the decision is kind of open-ended. So maybe initially they said, we think there's 100 excess horses. And then 5 years later, they're going to say, actually, we're going to remove 500 horses. And the public doesn't get any input in that. And Congress foresaw this.
From their currently available information at that time, because it doesn't seem like there's a specific mark, like quarterly or annually or.
Right. So Congress, if you look at legislative history, they expected that these would be annual determinations. And they are supposed to look at currently available information, but they're also supposed to consult with independent parties. So 5 years down the road, if they decide, oh, now we think there's 500 excess horses, that should be reviewable and the public should be able to get input in that.
Right, and
Under
so
these
the public
decisions, they
involvement's
don't.
Public involvement's going to take a year and a half, and now they're ready to act after the year and a half. You're going to come back and say, no, you can't act because you have to do it again because circumstances have changed over the year and a half when you were consulting with the public. Is that what your argument is? So a year and a half, you're saying they're getting what they want to reduce now. After the original plan was played out as well as it could be. Now time goes by and they say, okay, we want to continue now with a reduction. You say, no, you have to have process and we have to be involved. Okay, you have it. And you fight over how many more? What circumstances have changed? You finish a year and a half later, because that's how long these things may take. And then at the end of the year and a half, you're going to say, when they say, well, okay, we're going to now move, you say, no, you can't, because circumstances have changed during the year and a half. So we have to do it again. When does it end?
No, Your Honor, I think.
You see what I'm saying? When does it end?
I see what you're saying, but I think one thing that you're misunderstanding is that the Bureau of Land Management is changing its decisions, not Friends of Animals. The Bureau of Land Management is saying 5 years down the road, we now think there's a different excess number. So our concern is that when it makes that new decision,
I totally understand that. When they make the second decision after the original plan and they're acting on the original plan, then they make it, and you want to be a part of that, and I'm saying you're a part of it. But it takes a year and a half to be a part of it. And now they're getting ready to act again. And you say, but wait, there was a bad winter during that year and a half when we had notice and comment, and things have changed, and a number of horses have passed away, and fertility is different. So you still can't act because we have to participate again with you. When does that end?
well, Your Honor, that is not the situation here, but I think all that,
Trying to
I would say it
understand-
ends, once one place to draw the line is BLM says it needs to remove 100 horses. Once it's removed 100 horses, it can't go back and then say, we need to remove more without that process.
You won on that issue.
No, respectfully, Your Honor, the district court had tied the decisions to the appropriate management level rather than an existing overpopulation. So that is what Friends of Animals disputes, is that BLM can't go back and remove horses merely based on appropriate management level. And BLM concedes this in the 10th Circuit and has said just because a population is over the set, target doesn't mean they can remove them. But under these decisions and under the district court's opinion, BLM could go back and continually remove more horses than originally proposed in its decisions based solely on the AML.
Do that after making a necessary to remove excess animals determination. They can't just do it on a whim. They have to make the determination. Now, I'm just reading from the district court. They can't just on a whim say, well, let's remove some now. They have to make the necessary to remove excess animals determination.
Well,
right? And they say you have to consider new information that is now before you in doing all of this. And you may have to have real process depending upon what's going on, what the issues are, which means you would be involved again. It depends on the situation.
well, respectfully, Your Honor, the district court kind of said, yes, BLM can decide when there's new process. What we think the act requires is that once it's completed one roundup, then it needs to have additional process, even if it didn't achieve, even if the target level it claims it hasn't achieved. If it removed the horses that it identified as excess in the original decision, then it should have to do that new process. The problem with these decisions is on their face, they're not limited to an existing overpopulation. On their face, they allow BLM to adjust the target removal numbers as the years go by. And that adjustment is what Friends of Animals is concerned of, because that's what Congress required, certain safeguards for. Congress required that BLM consult independent parties. Congress required that it makes a determination that the overpopulation exists and that removal is necessary.
And the district court said that the agency cannot ignore material new information that comes to its attention over time.
Yes, Your Honor, but not ignoring material information and consulting with independent parties.
And they may be required to have process depending upon what it is they're looking at any given moment. And that's where you can come back to the district court, because you may be at a place where they're saying, we want to have a reduction, we want to have a gather and a reduction, and we think because of X or Y, and you're saying, no, you have to have process. This is one of those situations where process is required. They say not happening. District court clearly invites you to come back and you can make that challenge.
Well, and can I point out one other thing that the Supreme Court has said in guidance on this in the Department of Homeland Security versus Regions of Southern California is that when an agency makes a new decision, it's a fundamental principle of administrative law that they have to explain their reasons for doing so, and they have to issue a new decision. That gets taken away under the district court's order and opinion, because now the burden is not on BLM to defend its decision. It's on Friends of Animals to say things have materially changed and to bring this appeal, in a matter of days, because BLM doesn't commit to providing any notice to the public, essentially forcing litigants and the courts to chase a moving target. That violates the Administrative Procedure Act, and that violates what Congress intended when it put these safeguards in the Wild Free Roaming Horses and Burros Act. It wanted the agency to provide this information, to consult with other parties. And I noticed that my time has passed, so I'm happy to answer more questions, but
Good shots. Yeah. We'll give you some time when we're done.
Thank you, Your Honors.
Mr. Peterson?
Good morning, Your Honors.
Could you give us the federal government's view on finality?
Yes, Your Honor, that's what I was going to start with. May it please the court, my name is Ezekiel Peterson. With me at council table is Steve Geary, representing the state of Utah. My plan is to speak for 8 minutes before turning it over to Mr. Geary. I'm hesitant to get too far out over my skis on jurisdiction just because we didn't brief it and we didn't contest it. What I think
we have to decide it.
I'm
It would be
aware
nice to have the federal government's views.
Yeah. Let me start with how BLM construes the district court order, because I think that shades the jurisdictional discussion a little bit. Our understanding of the district court order, and I think this is consistent with what the plaintiffs have said, is that the gather plans are still left in place insofar as they allow BLM to remove wild horses down to AML in these herd management areas. So that is still in place. BLM did some of that work, I believe, after this decision came out. And that's, of course, subject to the limitations that the district court put on those gather decisions at the order of pages 50 to 51, saying, they still have to be conducted as promptly as reasonably possible, subject to the statute. They can't be based on information or consultation that's materially out of date, but the government can still go forward and remove wild horses down to AML. They can't do maintenance after that, of course, and we don't contest that, but we can gather down to AML. So with that, I mean, I'd like to focus on.
Do you think, does the government have any obligation under the remand order to amend the plans?
I think insofar as the government, our understanding of the remand order is that we have to amend the plans if there are some sort of material changes in condition or changes in consultation, or if the government wants to do anything beyond gathering down to AML. But other than that, no.
I'm not sure it is critical for jurisdictional purposes, but I had read it to require you to clean up the plans a little bit insofar as he found them essentially overbroad.
I think our position has been that is kind of confined to the portions of the plans that I discussed, not the portion of the plan that is just a straightforward gather down to AML as reasonably fast as possible.
No, but after he knocks out the maintenance part, he says, separate and apart from that, no carte blanche to conduct gathers years from now.
Yes.
But because the Bureau is better situated to draw those lines in the first instance, the court will remand to the Bureau, which can revise the decisions to clarify which future gathers will require further process.
Understood, Your Honor, and I can discuss that with my client.
You can't ignore material new information that comes to your attention over time.
That's correct. And we don't dispute that if material new information comes into play, BLM is not allowed to conduct further gathers without considering that material and new information. That's not an issue on appeal. Neither BLM nor Utah have
Still
challenged.
got to make the necessary to remove excess animals determinations.
That's correct.
I thought the district court also said in some situations, given the circumstances, you may have to have new process.
That's correct. When material new information comes into play. And we don't dispute that. That's not an issue in this appeal.
Or when there's very substantial delay.
That's also correct. And that, goes to the statute's requirement that.
And that they can come back to court if they disagree with what you're proposing to do, and they're making a claim there's new material information, which they've totally ignored. The necessary to remove determination makes no sense. They can challenge you.
That's correct, Your Honor. I think they would have both administrative and judicial remedies insofar as there is some sort of they allege there's some sort of new material, new information.
Now, let me just make it clear. I didn't think this was the case. I don't mean to sound frivolous with this, but this doesn't happen that someone out there says, let's get rid of 100 horses. It's Sunday and they say, well, let's do it Tuesday. Don't tell anybody anything, move quickly.
No, Your Honor.
That isn't what's going on, is it?
No, Your Honor. In fact, my understanding is there's a lot of opportunity for the public to come out and observe these gathers. These gathers are planned months in advance because, of course, they're subject to significant constraints around, on-the-ground conditions, around the agency's funding. So the agency has a schedule of gathers that are scheduled to happen.
The only reason I'm raising it is because they're concerned about not being able to object or raise challenges to raise questions that the district court has raised can't be met because there's no time. That's not the picture I'm looking at. I think that's not correct. Is that right?
No, yes, Your Honor. We would agree with you that just the practicalities of how these gather decisions are implemented means that there would be time for Friends of Animals to raise objections insofar as they think there's some sort of new material information that the agency needs to consider.
So I had thought you had to amend the plans, but I see how you're reading this. So let's assume you're right. Then the way judicial review would work is the plans are what they are, and there may be as applied issues in the future. And when you do a subsequent gather pursuant to a plan, that is separate agency action, and someone like Friends of Animals can go to court and say that it is either unlawful or inconsistent with the district court remand order.
Yeah, I don't want to get in trouble by stating for the government that a follow-up gather is necessarily an agency action that is challengeable under the APA.
Well, if you don't say that, you're making your jurisdictional case harder, because if you have neither a plan amendment nor a later agency action, then it sort of looks like they're going to have a tough time getting into court later.
The way that I was thinking about it, that the government was thinking about it, was that if there's some sort of material change in condition or change in information, or if Friends of Animals or a plaintiff group believes that there's some sort of unreasonable delay under statute, that they would have the opportunity to petition the agency under the APA, and then that decision would be reviewable judicially.
For unreasonable delay?
For the agency's response to that petition would be reviewable under the arbitrary and capricious standard.
And sorry, what's the they petition not to do the...
Saying either there's this new information that BLM has not considered.
What's the precipitating event? That's what my colleague's asking. Is it the proposal to gather, or is it the necessary to remove decision, which would, I think, follow the gather, right? The necessary to remove?
I think
You gather before you make the necessary, I'm asking.
Yeah.
You gather before you make the necessary to remove decision, right?
You make the necessary to remove decision
Before
you gather.
Okay.
Yeah, there's an excess determination.
Right.
Yes. And then
So what's the starting point is what my colleague is asking. What is it that they can first object to? The necessary to remove decision, or the gather decision, or what?
I think in this hypothetical, we're assuming that there's a gather plan like the one at issue here that kind of authorizes some sort of actions in the future, not just one individual gather. So I suppose it would be the scheduled gather that is coming up, the BLM's decision that they're going to institute a gather.
That is premised on a necessary to remove decision.
Yes.
Premised on the one that's already been made, that on your view, you don't need to reconsider.
That's correct. Our view, we don't need to reconsider absent some sort of material change in circumstances or new information. Yes.
So you've got the Gutierrez decision that basically said remand order is not final, but what about Limnia? How do you interplay those two?
Yeah, and again, we didn't brief this, but my understanding is this is more in the Limnia category than the North Carolina Fisheries v. Gutierrez category. The district court's order here, I think the way we've been reading the order, Friends of Animals has been reading the order, is it still authorizes BLM to continue, taking this action in a way that they disagree with.
And has BLM ever achieved these appropriated management levels?
My understanding, based on the most recent data I've seen from the agency, is that in some of these HMAs they have, but in, say, the Eagle Complex HMA, the appropriate management level is 145 to 265. And as of March, there were still 2,300 wild horses on the range.
So are these gathers still ongoing?
One moment. I don't believe that the gathers are ongoing under these specific plans, but I would have to check with the agency. I see that I'm out of time. I can speak briefly about the merits of this case if the court would like me to, or answer any questions about it.
BLM suggests that these appropriated management levels don't have to be based on current information. You want to speak to that?
BLM suggests that, BLM agrees that when the agency makes the overpopulation decision, it has to do that based on current information, and it did that here. If you look at
information as is available,
as is available to the agency when it makes the determination, I think it's crucial to see these decisions at JA 851. It says, without action, this extreme overpopulation of wild horses on the range will result in deterioration of rangeland resources, destroy native vegetation, native plant communities, could result in danger of human safety as horses expand in range and go into public highways.
At which the information doesn't seem current, so to speak, like you have a time period at which you're acting on currently available information, but then the removal of the excess had come way later. And so is there a sense of that you're not technically acting on currently available information?
I think that goes to what the district court said as far as whether there's a material change in circumstances. And here, no one has alleged that that's been the case. I think these ranges are still in a drought condition. It's still a case that they're drastically overpopulated with wild horses, and some action needs to be taken.
My biggest problem with your merits position is the requirement right in the statute that the removal happen immediately.
Yes.
That's a strong word.
I agree with you, Your Honor.
You've made a great case that there are all sorts of exigencies, and maybe we need a degree of wiggle room in how immediate is immediate.
Yeah.
But is there any rational view of the world under which immediately means a decade?
So I would have two responses to that. One, a textual response about another word in the statute, and one...
Yeah, give me the textual one.
Yeah, one is a blush on the word immediately. The textual one is that in that same subsection, section 1333B2, it seems to contemplate that gathers to achieve AML will not happen all at once. So once BLM...
Yeah, fair enough. That's right. But
it states that action shall be taken, quote, until all excess animals have been removed. So I think that necessarily recognizes, in a case where you're removing 2,000 wild horses, and Judge Edwards alluded to this, the geography of the basin and range in Nevada and Utah means that you just can't do that all in one gather. You can't do that with one helicopter.
It also says BLMs to proceed in a specific order and priority, assuming step by step.
That's correct. Those A through C procedural requirements also contemplate that
Assume that step by step is over a period of time, and it's certainly not going to meet any reasonable standard of immediately.
Precisely, Your Honor. And then the second, the blush on the word immediately is that the fact that an agency must start acting immediately doesn't mean that they have to complete their action immediately. I think the District of Utah recognized this in the Western Rangeland Conservation Association, where they said that the physical removal of wild animals just can't happen instantly. It can't happen at once. There's necessarily some sort of delay in doing that. And, we agree that the BLM, according to the statute and according to the amendments that Congress passed in 1978, can't wait forever to remove excess wild animals from the range that are causing damage and aren't in a thriving natural ecological balance. But it can't happen all at once, even though the statute says immediately.
No doubt about that, but I'm not sure that gets you a decade.
Fair enough, Your Honor. I think,
And sorry, you said you had 2 points. Could you give me your second one?
oh, the second one was the blush on the word immediately that I just discussed. I think just to briefly touch on what you mentioned, the a decade, these these are not saying that BLM is going to wait 10 years and then is going to start implementing them. They're simply recognizing because of practical considerations, it could take a while. And I will grant you, it does say 10 years. It could take up to 10 years. It authorizes up to 10 years in the decision. But BLM is still expected to start achieving that as expeditiously as reasonably possible.
Judge Childs, any other questions? Judge Edwards? Okay, thank you.
Thank you, Your Honors.
You're from Utah. Mr. Geary.
Thank you. May it please the court, Steve Geary on behalf of the state of Utah. I do want to be clear at the outset, the state of Utah does join the Bureau's arguments, both in the briefs and an oral argument here today. Utah takes its brief time to address a couple of issues that were unique to the Utah brief. The first of those was Utah's standing, which I did clarify with counsel before this oral argument. Friends of Animals has not abandoned their challenge to Utah standing, but I think they were inclined to submit that on the arguments in the opening brief. Unless the panel has questions specific to that, Utah would do that as well and submit on our brief on that. The other issue that was unique to Utah's brief was the issue that the panel is quite interested in, apparently, which is the mootness. And the jurisdictional question.
Well, finality, not.
Finality. Thank you, Your Honor.
I think your position seems to me pretty strong, to be honest, but one possible fly in the ointment, I thought the best case on the other side was American Great Lakes. So can you just give me your...
Well, and we discussed that somewhat in the brief. One point that I wanted to make out to this panel as well, though.
I mean, it's a remand without vacature where the rationale for the immediate appeal is that the party that secured the remand didn't get the vacature and is going to be subject to harm.
Well, and the party in that case is harmed by the remand itself. So in Great Lakes, they're very much, as I think we explain in our brief, they're in the same sort of situation that the federal government would be in challenging the remand. That look, the remand itself is what is going to cause the harm to us. If we cannot have that heard now, then we never get the relief. Here, Friends of Animals actually had 3 other claims in this litigation that the district court finally disposed of. Those are their claims. Number 1 to the
Sure, but let's just focus on the remanded claim. They're saying, well, as of right now, the situation on the ground is BLM can continue to gather.
BLM can continue to gather, subject to the provisions that the panel is already well aware of.
Fair enough, but their legal position is no future gathers without full process, period, full stop.
But no one knows what BLM will actually do until after the remand and the plans are revised according to the court's order. And what we have here is not a complete agency action anymore. We have an agency action in which the district court has poked some rather significant holes in it. And although parts of it have been left intact, nobody knows at this point what BLM will retain of that after it remands and reconsiders. The only parts that,
even though they've just represented that they don't have to formally amend the order at all, and they can just keep going. And
well, they can keep going.
Maybe 8 years from now they'll hit the speed bump on immediately.
except these are 10-year plans that were passed in 2017 and 2018. And I think, as Judge Edwards noted, we're coming up, and this is not an immediate process, notwithstanding the immediacy of the statute to implement it. There's still notice for any individual gather, and these are published on the BLM's website. The public and Friends of Animals does have the opportunity to address specific attempts at harvesting the horses and challenging those in the court, and they can still raise those claims in regard to that. But the reason I brought up the other claims that the court finally disposed of is those claims, the NEPA challenge, the Anaqui Roundup, and whether or not the Bureau is complying with its past regulations or not. Those have all been abandoned on this appeal. They're referenced nowhere in that, though. So those points, they are final decisions. The court would have jurisdiction to do them. But Friends of Animals has not brought them to this court. What it has brought is challenge to the Wild Horse Act management.
I'm not sure how that helps you, but yeah. I don't think it hurts you.
Yeah.
Childs, questions, Judge Edwards?
Other than that, we would submit and ask that the court affirm.
Thank you. Ms. Best, we'll give you some rebuttal, 2 minutes.
Thank you, Your Honors. The one thing I wanted to emphasize real quick is the Supreme Court said in Lumnia that the finality requirement should be evaluated based on the practical effects of the district court. And in practice, what can happen right now is next year, BLM decides to round up and remove 1,000 horses from the Eagle Complex herd management area. Horses will die in this roundup. Horses will lose their freedom forever. BLM is not going to issue a new decision. BLM has not committed to provide any specific public notice. BLM has not committed to consult with independent parties. We think all of these requirements should apply, but BLM instead is going to rely on the decisions issued in 2017 and 2018 that are at issue right now. So as a practical matter, Friends of Animals can't go back and challenge those decisions. And BLM will argue there is no new final agency action. And because this didn't come up.
They're going to act pursuant to the original plan.
They will act pursuant to the original plan, correct, Your Honor. And because BLM didn't dispute this, I don't believe it's part of the joint appendix, but it is a part of the record. There was some discovery done in the district court because the district court also had questions about jurisdiction. And in response to interrogatories, BLM admitted that it finds that the notice that was required happened back in 2017 and 2018. Any public comment happened back in 2017 and 2018. Therefore, it doesn't think it's required to do that when it does a roundup in 2026. Friends of Animals.
Is it remotely realistic that they can engineer a roundup, which seems to require lots of planning and lots of logistics and lots of people involved without your knowing about it?
Yes, Your Honor. They will, they can contact contractors. They can request funding. And in fact, this happened with past roundups, all internally without notifying the public. And because these are separate, distinct roundups where BLM has to request funding every year. It has to get approval. It has to get a contractor. It's for those distinct roundups where Friends of Animals saying, hey, this is where the law applies and where you have to get public input too. So it's these distinct roundups that Friends of Animals says the requirements of the Wild Horse and Burro Act apply. We know BLM has an extensive internal process, so why can't it also comply with the Wild Horse and Burro Act each time it's determining to round up and remove horses?
Are they proposing, as far as you understand, to round up and reduce pursuant to the original plan numbers?
Your Honor, so the original plan, this is another concern, doesn't have specific like excess numbers that they're going to round up and remove. It leaves that open-ended so it can decide in 2026. Now we want to remove 1,000 horses, and it didn't disclose that back when it issued the original decision. So clearly that harms Friends of Animals because we have no opportunity to say this amount of horses shouldn't be rounded up.
Well, I
Because
mean, you're making an argument, you're doing it implicitly, but I think it's pretty clear to us. You're suggesting that this could happen and you would not have notice to get back, enough notice to get into the district court to challenge it. That just seems implausible. I mean, you've got to say or do more. Tell me something or point me to something to convince me. There's no conceivable way that I'm going to know that they're about to do a roundup and reduction involving 1,000 horses, and they'll have it done before I can get back to district court and say they're violating the mandates of what the district court addressed in this case. That just seems, I'm being very honest with you, that seems implausible to me, that you would have no opportunity to raise that in district court.
well, I think there's two issues that I'd like to address about that question. First of all, we disagree with the district court standard. So
I hear you, but let's assume it's there, all right?
Okay.
Would you just do me a favor and answer the question on implausibility? I'm not facially buying it when you suggest there's no way we could get to the district court in time to raise this concern. Block it if we had a legitimate claim.
Yes, and Your Honor, I think, if it'd be helpful, I can submit additional material from the district court record that where BLM says we're not required to provide any notice.
Counsel,
So
you're missing my point. We're looking at the district court's decision. So whatever interactions went on, that's fine, but we're looking at the decision. The district court said you have to take into account new information, prompt and reasonable. There may be times when you need process. You can't ignore material new information. You're hypothesizing they're about to do something that's going to violate those standards. And I'm saying to you, you go back to the district court and say they can't.
So, Your Honor, if there's no requirement, they don't perceive any requirement for
I
public notice.
understand that's the fight. You're going to go back. You would make the argument this is totally unreasonable. It's not justified. They haven't considered new information and they haven't talked to the people who might know something. You may not win it, but you're certainly not foreclosed. And more importantly, you're not going to be out of time.
Your Honor, there's nothing precluding them from telling the public on Friday afternoon, we're going to start this roundup, a helicopter roundup on Monday.
Okay. And
So-
you think that could plausibly happen?
Yes, Your Honor, I do think that could plausibly happen. And maybe if it's not Monday, okay, we'll do it Tuesday or Wednesday. And how is Friends of Animals, yes, as a practical matter, to talk to our members on the ground to say, what are the conditions here? What did BLM get wrong when we don't even have a record of their decision? And we need to brief this before the district court. As a practical matter, we can't do that. And especially when BLM's going to say, look, we're relying on the decisions in 2017 and 2018. We don't need a new record. We don't need a final agency action. So as a practical matter, Friends of Animals can't get to the court.
Thank you, counsel.
Thank you, Your Honors.
Mr. Peterson, would you come to the podium for a moment?
Of course, Your Honor.
You've heard my question. Is my concern well taken? Is it possible that BLM on Friday, after doing everything behind the scenes secretly, could announce Friday at 5:00? Oh, incidentally, Monday at 9 a.m., we're starting a roundup and gather.
I'm going to qualify my answer, but I don't think that would happen. I can certainly talk with my client and submit a 28-J letter if the panel would find that helpful. But based on my understanding of just the practicalities of organizing, as well as how far in the future these things have to be planned and are made available to the public, there is a public gather schedule. That would not happen.
Okay.
Okay. Thank you.
Thank you, Your Honors.
The case is submitted.
Case number 24-5277. Axel Diegelmann et al., appellants versus Scott Bessent in his official capacity as Secretary of the United States Department of Treasury et al. Mr. Tusi for the appellants, Mr. Janda for the appellants.
Mr. Tusi, good morning.
Good morning, Your Honor. Excuse me, sorry.
Whenever you're ready, no rush.
May it please the court, my name is Amir Tusi and I represent the appellants in this appeal. I would like to reserve 2 minutes for rebuttal. On February 23rd, 2024, the appellants were designated by OFAC to its SDN list for allegedly operating in the metals and mining sector of the Russian Federation economy. And based on the law, they should not have been. OFAC itself defined the term metals and mining sector of the Russian Federation economy, and its designation exceeded the boundaries of what that definition included. By their own words, in their brief in this case, they are urging a broad and expansive view that goes beyond the text of the language that is contained in that regulation. And specifically, I'm talking about 31 CFR 589-325, which I'll refer to as 325, section 325 for ease of reference. First of all,
There are a lot of different arguments floating around in this case about the meaning of procure and the geographic nexus and so on. I think your best one, and I think it's a very strong one, is that geological materials means unrefined stuff, not gold bars or diamond rings.
right.
You didn't make that argument below. Actually, you argued the opposite below. You used geological materials as shorthand for finished goods.
Well, I don't believe that we use it for finished goods. Your Honor, if you could point me to what you're referring to, I would appreciate it. But our entire argument below was that the regulation was based on the production process, distinguishing between the manufacturing of these products and their retail sale. And so our argument is within the same thing, within the same vein of argument in terms of what type of activity this includes. And
You said, I'm getting this from, first of all, there's nothing express in those summary judgment briefs that geological materials means raw as opposed to finished. And the way you frame, the closest you come is this argument. You say there's no allegation purchased any precious metals from inside Russia. You use precious metals as a shorthand, which to me sounds much more plausible that includes finished goods as well as raw materials.
well,
And then at page 6 of your reply, you say that the whole scheme, the whole reg is focused on the production of geological materials,
correct.
not their sale. So you're saying that the geological material is the gold bar or the diamond ring, and this is all about producing that rather than selling it.
Well, I would disagree with that characterization of what we were saying. What we were saying was, in that context, was to the extent that these geological materials are taken out of the ground and then produced for retail sale eventually, we were distinguishing between that and that activity and what the appellants were engaged in. So if you, and there is a tail end of the production process, which we've acknowledged, which is the transportation of the finished goods. Obviously, a manufacturer, the final step in the process of manufacturing is delivering it to the market. But the appellants didn't engage in that activity, and it's not even alleged.
Seems like it's a different argument from the one you're pressing in the blue brief, which is that geological materials means raw materials.
No, well,
You clearly make on appeal and you make it forcefully, and I find it somewhat persuasive, but it's not in the summary judgment briefs in those terms.
the reason why the geological materials argument specifically is raised here is in the context that you're talking about, Your Honor, is that the way that the district court construed it to basically remove the prefatory language to say procuring geological materials. That was not an argument that was raised by the government in the district court. It wasn't something that we had an opportunity to respond to in terms of the court looking at it that way.
Fair enough. And you have that argument, which sort of combines the string of gerunds and the geological materials point. But I mean, you argued below this very distinct and to me very unpersuasive argument that procure means the only sensible object of procure is mining equipment, and you lost on that. And you didn't make, I'm repeating myself, but didn't make the argument keyed to geological materials.
We didn't make that argument specifically, Your Honor, but I would say that argument is not precluded on a de novo review because it's part and parcel of what the overall argument that we were making. In terms of the specifics about procuring, yes, we argued that it has an industry-specific meaning to it. And we continue with that, and I do want to respond to that in terms of what the government has pointed out in terms of FAQ 1117. But the reason why I don't think that the argument that we made below and the argument that we're making here are any different is because they're part and parcel of the same argument that is part of the production process. And distinguishing between...
They have the same feel, but they treat the phrase geological materials differently. And I'm struggling to think, is that close enough for preservation?
I would argue that it is, Your Honor, because at the end of the day, the geological materials, whatever you have in the refined materials that are out at market, at some point they were the geological materials. So it's not that we're not saying that gold is not a metal. That's not what we're saying. We're not saying that gold didn't emanate from a geological material. But in terms of the idea of what is this regulation specifically geared towards, what activities it's specifically geared towards, our overarching argument was that it was geared towards the production process, not the retail sale. And that goes to our arguments in terms of FAQ 1029 and 1070, where OFAC clearly was distinguishing between retail sale and manufacture. So I understand your point.
The OFAC determination does not support that view. The OFAC determination is very broad. Any person determined pursuant to the executive order to operate or have operated in this sector shall be subject to operated in this sector. That's the broad read, which is what they're acting on. And the determination's higher than the questions and answers in terms of its authority on the books, I think. At least that's where I'd be more inclined to look if I was going to defer to something or get a sense of the government's position. That's where I've always gone, is to the determination, not the Q&A.
So so with respect to in terms of the breadth of something, yes, the determination allows for the designation of anybody who operated in that sector, but that's not that's not the argument here. The argument here is specifically when they do define the sector. You know, they can say we're going to sanction anybody in the lumber industry, anybody who's operating in the lumber industry. And they actually don't even need to provide a definition of what it means to operate in the lumber industry. But once they do, they've confined it to the textual language of what it means to operate in that. And that's important for market participants to understand, what are we allowed to do? What are we not allowed to do? Or if we've engaged in that activity before, are we subject to sanctioning, and what response are we going to take? So in terms of the breadth, I do not dispute in any way that OFAC has a tremendous amount of authority to craft the rules, to craft them as broadly as they want to. But once they do, the text matters. The text of what they've said. And what they said in the metals and mining sector was any act or process or industry of extracting at the surface or underground, and that's a key phrase here, ores, coals, precious stones, and any other minerals or geological materials in the Russian Federation. And it's been our position from the very beginning that all of whatever the read on this, it has to emanate from the Russian Federation. So for example, it's actually difficult to understand exactly what the government is arguing at different points, to say whether is it Russian individuals who are purchasing metals regardless of where they came from? Is it other people buying Russian materials regardless of where those came from, or where the defendants, the appellants got them? But at its core, the limitation here is in the Russian Federation and at the surface or underground.
Limitation for in Russian Federation dealing with the materials being there, as opposed to who the procurer is or where their location is.
I would argue yes, absolutely. It's based on where the geological materials are being extracted from.
And so when we get to procure, though, that person or entity doesn't have to be in Russia. Or are you suggesting that they have to be the same?
Well,
the materials and the activity.
What I'm arguing is that the procuring relates back, because when we get to that litany of the other processes, or the other, I shouldn't say processes because processing is one of the words, but when we get to that list, procuring, processing, manufacturing, or refining such geological materials, that such geological materials is referring back to the geological materials in the Russian Federation. So what we're talking about is procuring those in that area, and going.
Right. So if there's no evidence that your client buys raw materials, right, the stuff out of the ground, right? Your client is buying finished gold.
I haven't seen the classified record, but based on what I know of the case,
okay, let's just assume that. So yes. There's this threshold issue about geological materials or procuring geological materials. If it's unrefined stuff, you win. If it's refined stuff, then we come to this geographic nexus point, which I think Judge Childs was talking to you about. So you have a buyer in Germany or Liechtenstein or wherever buying gold, finished gold, right? Assume that for purposes of the question.
Yeah.
Buying finished gold from Russians. If the gold is in Russia, it seems like this is clearly covered.
If it's coming from
German buyer, Russian in Russia selling gold to German buyer, that's covered.
Yeah, I would concede that it is, and I would concede that it's under the transportation, because if the person is involved in the transportation out of Russia, then that would be the hook.
It might be procurement, but so then the question is, the government says, well, we're focused on buying gold from Russians, and as a legal matter, that's not enough, right? That's your Alex Ovechkin hypothetical, right?
If you're a Capitals fan, sure.
I like that. I've used Ovechkin before as hypos. But why can't they reasonably assume, let's just hypothetically, if someone is regularly buying gold from Russians in substantial quantities, and we don't know a lot, it's not a one-off from some guy who's in London, can't they reasonably assume that some of it is coming from Russia?
I think that there would be a lot. I practice in New York. I think there would be a lot of people on 47th Street that would be shocked by that assumption, because there's a lot of Russian nationals living in this country. There's a lot of Russian nationals living in Europe. And just because they're purchasing gold because they want to invest in it or for whatever reason, I don't think that it's fair to assume that it's coming from Russia or that there's a Russian nexus under this determination. I mean, if you took the government's broad reading to its logical conclusion, if I were to have, say, 10 years ago, when the financial markets were collapsing, I wanted to invest in gold to protect my investments, and some of that gold was of Russian origin, I would be subject to sanctioning just because I had purchased the finished product in another country, even though I had nothing to do with transporting it from Russia or anything else. Similarly, if a Russian person living in the United States is going to buy gold, I mean, if we're going to tell the entire market, let me put it a different way. Financial services sector. OFAC has sanctioned that sector of the Russian Federation economy. They've defined that sector, right? But they haven't defined it they've never indicated that a Russian national holding a bank account in the United States would be something that would be sanctionable conduct, or even holding a bank account.
The reasonableness of the inference might depend on the nature of the buyers, the extensiveness of the buying, right?
Well, I think then you're talking about something a little bit different, because I also recognize that there, in terms of the deference that this court owes to OFAC, I would argue it's not on their legal interpretation. It is on, it would be in terms of their fact gathering and their analysis of those facts. But I would think that
suppose we say on the law, de novo review, we say the standard means the transaction has to involve gold that is in Russia. But then they get deference. They get a degree of deference if they're going to say, well, okay, but we can fairly assume that, this buying, whatever it is, which we can't talk about and you don't know, supports a reasonable inference that gold is coming from Russia.
I think you would have, if it's based on the nationality, or if it's based on simply on the origin, regardless of where it's originating from at that moment, then no, I don't think it's a fair assumption.
Okay.
If it's originating from Russia, then I think, and it's the finished product, then I would agree that, and if that's what we're dealing with, then that's a different story, because then I would say that is within the transportation to, from, or within the Russian Federation. So that's what I think characterizes it. And to draw the point, I know that the government has drawn a distinction on EO 14068 and the FAQ 1070, but that they haven't cited any reason to believe that an executive order in another circumstance can't give some sort of guidance on this. But OFAC specifically said, they specifically have a determination and an executive order that there's not to be importation of gold of Russian origin into the United States. They've made that distinction, and they didn't, and they opened it up up until June 22nd, 2022. Indicating that importation and that origin mattered, and where you were getting it from, where you were specifically buying it from, did matter.
Judge Johns, any questions?
No.
Judge Edwards?
Yeah.
Okay, we'll give you rebuttal.
Thank you, Your Honor.
Janda.
Good morning, Your Honor, and may it please the court. Sean Janda for the federal government. Under Executive Order 14024 and the 2023 sectoral determination, OFAC may designate any individual or entity who has operated in the metals and mining sector of the Russian Federation economy. OFAC concluded that Rheingold and the Diegelmann plaintiffs have so operated in a variety of ways because they've bought and sold precious metal in transactions involving or on behalf of Russia-based persons, have collaborated with Russia-based metals companies to disguise the origin of Russian precious metals, and have assisted Russian persons with laundering funds and circumventing international sanctions.
Is this rule with respect to thinking about the plain meaning of procure and that meaning simply to obtain? Can the rule be too broad sweeping if somebody buys this on the secondary market?
So I don't think so, Your Honor. And let me say a couple things. I mean, one, I think procure just means to acquire, maybe to acquire with some degree of effort. And that's certainly what the plaintiffs here were doing. In a different case involving someone who is 2, 3, 4 steps down the line, if there ever were such a case, the court might be able to think more about whether procure necessarily involves kind of a commercial acquisition rather than sort of a retail secondary down the line acquisition. There might also be work done in that sort of case by the necessary nexus to the Russian economy.
At least right now, as you stand in front of us, you're not thinking about that downward trending.
I think for purposes of this case, all the court needs to say is that when you have these precious metals companies, this precious metal firm that is acquiring in these commercial transactions, precious metals from
Precious
on behalf
metals
of
in finished form.
correct. I think the court can certainly assume that that's what's happening. And I mean, I can talk about the geological materials argument. Number one,
Finish.
well, I think the court can just focus on that for purposes of on the commercial acquisition, which clearly constitutes procurement, and leave for another day. Again, if OFAC ever were to sanction that sort of downstream person, I don't think the plaintiffs have pointed to anyone who OFAC has actually designated on the basis of those sorts of transactions that might cause concern. Focusing on the geological materials argument.
Let's talk about that. And it's not just geological materials. It's the entire phrase procuring, processing, manufacturing, or refining geological materials, which follows a phrase extracting at the surface or underground.
So I
Do you
think,
think that covers gold traders?
yes.
Do you think we would say, does Tiffany's procure geological materials?
I think so. I mean,
It's like a wildly implausible use of language to me.
so let me say two things. I mean, number one, I think here you're talking about sort of refined or finished gold.
Right.
You're not talking about, as I understand it, gold or silver that has been made into jewelry or watches or sort of retail goods in that way. You're talking about.
Right, but it's not, it's not the stuff coming out of the ground.
It's not the stuff that's come immediately out of the ground. I mean, that's certainly true. But for beyond that, number one, I think when you think about geological materials sort of in combination with precious stones, with coal, with the sort of other items in that list, it's exceedingly natural to refer to sort of finished diamonds, cut diamonds, processed diamonds as precious stones.
Precious stones is the best term you have, but the gerunds all seem like they're focused on taking stuff out of the ground and then processing it into usable goods. And some of the nouns, ores and coals, are the stuff you take out of the ground.
Yeah, I mean, I think then you get
The overall focus of this just does not seem like it covers.
And I think then you get to transporting it, which I think, I mean, even from the podium, my friend on the other side's acknowledged that transporting processed or finished or refined goods, geological materials counts. And so at that point, I mean,
Well, transporting them, which raises the question what the them is. Which
I think
takes us
them refers back to the but I think
geological materials.
I mean, maybe I'm wrong. I understood my friend on the other side to say from the podium today that he thinks that after the refiner refines the gold and then transports it, that transporting is covered. Which again, I mean, sort of drawing a distinction between.
Just work with me. Suppose I think them is just a pointer back at geological materials.
Well, I think that if plaintiffs acknowledge that transporting them refers to transporting finished products and them just refers back to geological materials. I don't know how you cut off the reference back or limit the geological materials in the second clause.
Trying to figure out the best reading rather than something that's driven either by a concession at the podium here or by a possible district court forfeiture.
Right. And then the other thing I'll say is I think just taking a step back, the sort of bottom line question is whether the plaintiffs have operated in the metals and mining sector of the economy. And the definition here is not.
I have two reactions to that. One is you conceded below that the meaning of that comes from this 31 CFR 589.
Right, but I don't think that the sort of list of activities in the regulatory definition is meant to be exclusive. I mean, it says includes these things. It's not only these things. And so just again, sort of at the kind of initial step, the question is whether buying, selling, transporting gold, sort of gold bars, silver bars, whatever it is, constitutes operating in the metal sector. And I think the answer just has to be yes.
Your district court papers say as a baseline, the parties agree about the scope of activity that falls within the phrase operate or have operated in the metals and mining sector. The description in 31 CFR.
I mean, I don't think we have ever conceded, and we certainly wouldn't intend to concede that the activities are exclusive. And the FAQ 1117 that's discussed in the briefs, which talks about the provision of goods to sort of companies operating in that sector, also potentially constituting operating in that sector, I think makes very clear that OFAC doesn't understand that the activities listed in the definition are exclusive.
I mean, I think you can argue that the plain meaning or sense of the defined term, which is metals and mining sector, can influence how we read the definition. But I'm not sure how much that helps you. Metals and mining sector in the singular likewise seems focused on certainly coming out of the ground. And I still have my linguistic intuition that you wouldn't say that Tiffany's operates in any metals and mining sector.
I mean, I don't know exactly what Tiffany's does. If
I'm
Tiffany's
just assuming someone who's buying polished, final, shiny gold bars or beautiful diamonds or things like that.
Yeah, I think certainly, look, if Tiffany's is buying gold bars, is procuring gold bars from Russia, they're operating, that act of procuring gold bars from Russia, in our view, would constitute operating in the metal sector of the Russian economy. And I think the other piece of this is the definition and the designation have to be interpreted in the context of the purpose of the sanctions regime, which is to isolate Russia from the international economy. And if the sanctions could be so easily circumvented, if Russia could access the international economy by refining the gold first and then selling it internationally, I mean, that would just be an entirely self-defeating sanctions regime. I don't think there's any reason to think that OFAC would have intended to construct a sanctions regime that can be sort of circumvented in that very easy way.
And I'm just trying to figure out how far you're going beyond the raw materials, for geologic materials. Are you extending it to something after refining or after resale?
So I don't.
What's that category that we're supposed to capture here? Because I just want to make sure that we're coming within any type of limiting principle.
Right. So as I understand it, what we're talking about in this case is materials that have been processed or refined, but they have not been sort of made into retail consumer goods. So we're not talking about sort of jewelry or watches. We're talking about gold bars or silver in processed or refined form. I would caution the court against saying that is the outer limits of what the definition reaches. I think OFAC has not sort of attempted ever to exhaustively document the outer reaches of this definition, and the court doesn't need to go there. But certainly in this case, we're focused on materials, metals that have been refined, but that are not sort of further processed into those sorts of consumer goods. And so if the court thinks that distinction is relevant or could be relevant, it could certainly kind of leave on the table the question about, if Tiffany's is buying gold watches, whether that would count. But the acquisition of even processed or refined goods, I think certainly with the purpose with the exceedingly expansive definition, I mean, I think the definition is meant to A, say includes, so it's not meant to be exhaustive, and B, talks about sort of any other geological materials, which is meant to be an expansive phrase, and is meant to capture, I think, a wide variety of geological materials. And again, I think the forfeiture point here too is exceedingly persuasive, and this argument is just nowhere in the district court papers.
And I want to take you to that next category of to, from, or within Russia. So let's, I want to see how attenuated you think that nexus needs to be with Russia. So let's think about if there was, would this cover a Swiss trader buying Russian gold from a Dubai intermediary?
I think it would depend on the particular facts and circumstances. I mean, there are two things I want to say. One is, as I said before, I don't think that the list of activities is meant to be exclusive. And so I don't think sort of routing your transactions through a Dubai intermediary is going to get you out of the procurement of the gold from Russia. That being said, again, it would probably depend on exactly, if you're thinking about whether it counts as transporting from, that would probably depend on exactly what the trader is doing. If the trader is saying, you know, I want you to ship it to this person and then ship it to me, I suspect that OFAC would think that that counts. I think certainly in this case, that I can't talk in too much detail about the specifics, but I don't think there's any question here that there's a substantial and direct nexus to Russia. And so at that point, I don't think the court needs to, again, sort of exhaustively document how attenuated the connection could get while still constituting operating within the relevant sector of the Russian
But
economy.
as a substantive matter, are you saying you are focusing us on transacting in finished gold with Russian nationals? And that seems to me not necessarily the same as transactions involving gold in the Russian Federation, which is the regulatory term. I think you need an inference from one to the other.
Yeah, I mean, number one, I don't think the regulatory term is talking only about transactions in the Russian Federation. I mean, I think even the plaintiffs will concede that if the Russian national takes the raw unrefined gold and, you know, takes it across the border to Belarus and then sells it to the refinery in Belarus, that the Russian refinery is procuring the geological materials and operating within the relevant sector of the Russian economy, even though it's not the one that sort of transported the gold, or even though the gold wasn't in Russia at the precise moment that the Belarusian refinery acquired it. So I don't think the gold has to be in Russia at that moment. I think there certainly has to be enough of a nexus to the Russian economy that you can fairly say that the individual or the entity is operating in the relevant sector of the Russian economy. And here, there's just so much of a commercial.
Well, is the act of disguising those materials still an act of procuring?
I think, I'm not sure that disguising is procuring. I think certainly the disguising and collaborating with the Russian-based metals company to disguise the origin of the metals constitutes, again, sort of working in the relevant sector of the economy. And this gets back again, the list of terms in the regulatory definition, it really is not meant to be exclusive. And so providing goods and services to particularly these sorts of specialized.
But did you also claim that appellants here disguised it?
What we have said publicly is that the appellants sort of collaborated with Russian-based metals companies to disguise the origin of Russia precious metals.
Right, that's what I'm trying to get at about disguising, if you're counting that as procuring.
I think certainly the collaboration on the disguising can be part of the act of procuring.
Okay.
And again, even if, I think this is a really important point that I do want to get across, even if all someone was doing, imagine you have a fully Russian entity and their whole business was working with Russian refineries to disguise the origin of Russia precious metals. They're not buying them, they're not selling them, but they're providing that service of helping to disguise them. I think we would say that that counts as operating within the metals and mining sector of the Russian economy, even though it's not buying, procuring, selling, transporting. It's providing these sorts of specialized services to the entities operating in that part of the economy. And to the extent the court's looking for, again, a place to get that aspect of the definition, I think that FAQ 1117, which talks about how it may constitute operating within the sector to provide goods and services to the people doing the procuring, the buying, the selling. And here, that's in addition to procuring themselves, that's exactly what you have. And that's enough to.
Give me a minute or two on the forfeiture point. I agree with you that they did not raise below an argument that the phrase geological materials includes refined metals as opposed to unrefined metals. But they did make an argument that the word procuring connected, the gerund procuring connected with all of the other gerunds, extraction, processing, manufacturing, refining, all center on production rather than sale. Why isn't that, it's linguistically different on what bucket geological materials is going in, but substantively it's the same thing they're saying here, which is this is directed at something sort of close to the mine and not sale of finished goods.
Yeah, I do think it is linguistically quite differently focused. It was just, a different textual argument.
But very similar in general thrust or this is going to sound pejorative, but vibe.
Yeah, but I think that the response to the argument sort of frame or that argument, which again, I think is a different argument, is that sort of you're talking about the processing, the refining, and then the procuring at the end of the day, the procuring the finished product, I think. And that fits in with transporting, which again, I think everyone agrees that transporting can include transporting the finished product.
Agreed.
And so procuring it, I think also could include the finished product. And so I think to make the argument have the sort of legs that they're trying to make it have in this court, really requires shifting to the definition of geological materials, which is it's just nowhere in the district court. And I would point the court, and to the extent that I think the plaintiff's main justification for the shift in argument is they think that the district court adopted some interpretation of procure that we didn't advance. And I would point the court to pages 13 and 14 of our primary summary judgment brief in district court, docket number 18, which makes sort of exactly the plain text meaning of procure argument the district court adopted. So I think they were certainly on notice that that was how we understood the regulation to work. And if they thought at that point that geological materials didn't encompass or sort of cut off at some point in the refining process, they could have made that argument then. They didn't do it.
Judge Childs, anything else? Judge Edwards?
No other questions?
Thank you, Counselor. Mr. Tucci, rebuttal.
Thank you, Your Honor. And I want to return to the question about transportation. And you made a comment about a concession at the podium.
I'm not sure you made it, but
no,
I'll give you a chance to clean it up.
No, I want a chance to clean it up because I was sitting there. I had a chance to think about it. And honestly, just candidly, a gear got shifted because I thought you were suggesting something to me that would be news to me. And I was thinking about that. But I do think that the them refers back to geological materials. And what I would argue is that if you look at FAQ 1029, that reading is confirmed. Because the 1029 asks the question, how did the prohibitions of Executive Order 14024 and other Russian-related sanctions impact gold-related transactions and persons participating in the gold market? And as it goes through, it delineates, you can actually see it tracking the language in EO 14024 as to what types of activity are prohibited. But it does not say that any transaction of gold coming out of Russia is prohibited. What it says is it may be, and it says it may be if it's designed to evade U.S. sanctions. That is part of EO 14024. A person can be designated for evading U.S. sanctions. The next bullet is financial services. That was already a designated sector at that time, it's indicating if you operate in that financial services sector through this transfer of gold, then you are subject to sanctioning. And I don't want to go through every single bullet because I don't want to take up all of the time. But if you look at 1029, what you see is that it is everything that they are basically saying, every single other reason why buying gold out of Russia, the finished product out of Russia, is not per se sanctionable, but rather might be sanctionable for some other reason that has already been stated. And it doesn't matter that this FAQ came out before the determination, because, and you can see it, they update these FAQs to reflect new guidance. So why wouldn't they have, they could have easily amended this to say, hey, you know what? We just had this new determination with about the metals and mining sector, and 1029 is inoperative. Any purchase now is per se sanctionable. They did not say that, and they very easily could have. So going back to the question of whether the mere purchase out of Russia would be sanctionable conduct, I would say no, Your Honor, because I do think that the them refers back to the geological materials.
Judge Childs, any questions? Judge Edwards?
Oh,
I'll give you a sentence or two if you want, but please wrap up.
just on this point of 1117. This goes to our procurement argument, which I gather is not winning favor, but my entire point about 1117 is that goods and services, the procurement of goods and services, that is why they put out that guidance. They carved out a specific exception for safety because the procuring in this section was actually related to that. But that being said, we rest on the arguments in the brief. Thank you very much for your time.
Thank you, counsel. The case is submitted.
Wonderful.